Hi, good afternoon everyone. I'm Sushma to moderate this session. We have with us Mr. Manoharan, our speaker of the day, on the call to walk us through vital aspects related to statutory compliance. Statutory compliance, an introduction to the essentials. Mr. Manoharan Krishnamurthy, National Head Statutory Compliance at ADP India, has over 20 years of expertise on all aspects of compliance, including labor laws. He has vast experience advising small, medium, and large enterprises in several industry sectors. He is an expert in handling and managing end-to-end statutory compliance services across the country. As on date, he handles 300 plus clients across India. Before starting the sessions, would like to thank each one of you to have taken your valuable time for joining us. I wanted to inform that all of you would be put on listen-only mode. We encourage our viewers to put forth questions that is related to today's topic and agenda. We will be pleased to answer them at the end of the session. Over to Mr. Manoharan.
Thank you, Sushma. Good afternoon, folks. This is Manoharan from ADP. Thanks for extending your participation for this valuable webinar. The webinar is intended to spread knowledge on statutory compliances to the best of my knowledge. This is not to be considered as challenging any veteran's knowledge in the field. When we talk about compliance, we do compliance for the business. I personally categorize business into two wider aspects. One, manufacturing. The other, selling. Again, selling split into two: selling a product or selling a service. When a compliance is done for the manufacturing, it is all covered under the Factories Act and the related legislations. And the compliances for selling a product or selling a services combinedly are covered under the legislation Shops and Establishment Act. Now I would like to take you through the acts that would be covered in this half an hour session. Maybe the session will be little rushing due to time constraints. Post the discussion, you are all requested to post your questions, which we should be in a position to respond back. We will be covering Factories Act, Shops and Establishment Acts, Employee PF and Miscellaneous Provisions Act, Employee State Insurance Act, Tax on Profession, Trade, Sealing and Employment, Labour Welfare Fund Act, Maternity Benefit Act, Contract Labour Regulation and Abolition Act, Minimum Wages Act, Payment of Wages Act, Payment of Gratuity Act, Payment of Bonus Act, Employee Compensation Act, Equal Remuneration Act, Payment of Subsistence Allowances Act, Employment Exchange Act, Industrial Establishment Act, which will be covering conferment of permanent status workmen and also standing orders, and the last, Industrial Disputes Act. We will be covering mainly on applicability of all the acts, maybe not in a much detailed way, as the time is not sufficient to take up in that fashion. We are entering into Factories Act. The Factories Act extends to the whole of India, and this is a centrally governed act. It is applicable for all over India. It is assisted by state-wise factories rules. Its enforcement is through state government by adopting their own rules. It applies to any manufacturing unit with 10 or more employees with the aid of power, or with 20 or more employees without the aid of power. Here the manufacturing is construed to be a raw material turning to become a finished goods. Shops and Establishment Act is a statewide legislation. Bombay Shops and Establishment Act being the parental act. All other statewide Shops and Establishment Acts are the byborn of the Bombay Shops and Establishment Act. Shops and Establishment Act, again as like Factories Act, is assisted by the state specific shops and establishment rules. This is also applicable for all the establishments that are scheduled in the state-wise acts. Employee Provident Fund and Miscellaneous Provision Act, otherwise called as PF, it applies to every establishment or a factory engaged in any industry in which 20 or more persons are employed. There is a provision for clubbing multiple establishments under one ownership under the Provident Fund Act. Also, the Act is coverable on having 20 employees or more, but there is a provision to have volunteer coverage even when the employee strength is less than 20. The employee strength is construed to be all employees including contracted employees. Even if the employee strength reduced less than 20, after taking coverage under PF Act will continue to be covered for the sake of employee benefit. Next is the Employee State Insurance Act. This is also central legislation, applies to non-seasonal factories using power in the manufacturing process and employing 10 or more persons, to non-power using factories or establishments employing 20 or more persons. This is implemented area-wise by stages. When we say implemented, ESI is such a provision which will facilitate day by day medical requirement of any employee coverable under the Act. The ESI institution by itself will give coverage to such employees when the employee strength is larger in a particular area. Where the ESI Act is implemented, only at those areas the employees coverable in this Act will be given with the benefit by ESIC Act. Other areas which are otherwise called as non-implemented areas will not get covered under ESIC Act. Appropriate government is empowered to extend any other area even if it is not implemented. This extends to any type of establishment including factories, shops, hotels, restaurants, whatever we name. For this sake, basically the factories and establishments are to be registered. We are on to tax on probation, trade, sealing and employment, which is otherwise called as professional tax. It is applicable to all the establishments in a particular state. It is a state-wise legislation. For a rough understanding, all the state other than the states in the northern area of India are covered by this act by their own professional tax acts. States beyond Madhya Pradesh, that is Uttar Pradesh, Delhi, Haryana, Punjab, Himachal Pradesh, Jammu and Kashmir and any other state in those regions are not covered under professional tax. All other states are covered. Every employee invariable of his designation and salary will be coverable under this act. The act varies for coverage on a monthly basis or on a half yearly basis. Some states have monthly remittance, some states have half yearly remittance. Within monthly and half yearly, some states have monthly location wise coverage, some states have monthly centralized coverage. Same way for 6 monthly also, some states have location wise 6 monthly, some states have centralizedly 6 month. The next is the Contract Labour Regulation and Abolition Act. This act applies to any establishment wherein 20 or more workmen are employed on a day in the preceding 12 months. On having 20 or more contract employees under a single contractor or multiple contractor, the principal employer have to register under this act. Any single contractor on having 20 or more contract workmen under his contract for a particular principal employer have to obtain a contract labor license under this act. We have to understand the difference between contract labor registration for a principal employer and for the contractor. I would like to repeat this. Any principal employer having 20 or more contracted employees under single contractor or multiple contractor have to register under this act. Any single contractor having 20 or more contracted employees under one principal employer have to obtain contract license. We move on to minimum wages. It is also applicable to all establishments but scheduled under the act. This varies from central government to state government depending on the governance. Establishments that are centrally to be covered like banks, petroleum industries, etc. will have to follow the minimum wages as per the central government guidance. Any other establishment which is not covered under central government will be covered by the respective states. It lays down principles for fixing wages for minimum rate, minimum time rate, minimum piece rate, guaranteed time rate, overtime rate. The act specifies that the payment has to be paid in cash, but in the recent scenario, even the check transaction and net transfer transactions are accepted by the authorities. Wage period can be by hour, by day, or by month. It can be weekly or fortnightly as well, but it cannot be extended beyond a month. Next is the Payment of Wages Act. It also extends to the whole of India. It applies to persons employed in a factory, an industry, or any other establishment. It applies to employees drawing salary not more than 10,000 per month. The main governance as per this act is any employee with an employer having less than 10,000 as per his employees should be paid with the salary on or before 7th of the following month. Any establishment or a factory having more than 1,000 employees can pay salary on or before 10th of the following month. Payment of gratuity. Every factory or establishment in which 10 or more persons are employed, that establishment will be applicable to be covered under the act. As like Provident Fund, once the act become eligible, it will continue to apply to shop or establishment even if the number of employees fall below 10. The minimum period for eligibility for an employee to take the benefit through gratuity is on an understanding 5 years, or otherwise it is 4 years and 240 days including leave with the wages. On other instance like death or any other scenario, the employee will have to be paid with the gratuity benefit to his next of kin. At any time, there is no time limit for this. Payment of bonus. It applies to all factory and establishment in which 20 or more persons are employed in any day during the accounting year. Any employee who is getting a salary, basic salary less than 10,000 is applicable to receive payment bonus. For calculation purpose, the basic wages is restricted to 3,500 rupees. For an understanding, any employee having basic wage between 3,500 and 10,000 has to be paid with the ceiling of 3,500 rupees. Anybody less than that can be paid according to the basic wages received. The maximum payable bonus is 20%. Minimum payable bonus is 8.33. There is a technical terminology called infancy period. First 5 years after starting an establishment is called the infancy period. If any organization running on a loss during infancy period need not to pay the bonus. If the same organization even in the infancy period is running on a profit, 8.33% mandatory bonus has to be paid. After 5 years, that is infancy period, even if the establishment is running on a loss, 8.33% of the basic wages has to be paid as bonus to the employee. Depending on the profitability, it has to be extended up to 20%. We switch over to Labour Welfare Fund. It is also applicable to all the states across India. The governance is by the state government. It applies to all employees except managers, supervisors drawing wages more than 1,000, an act apprentice, part-time employee. There is a clarity on manager here is any designated manager who do not perform the duty of a manager is not a manager under this act. Also, any person who is not designated as manager but performs the duty of the manager like approving leave, etc., will be termed as a manager under this act. Employee Compensation Act. The act imposes statutory liability upon an employer to provide payment to employees when they suffer from physical disabilities and disease during course of employment. Again, it extends to whole of India. Labour Welfare Fund is nothing but benefit extension to employee where any other benefit cannot be extended in case of his death or disability. Again, wherever ESI is not applicable, Labour Welfare Fund is construed to be applicable for all the employees. Unlike ESI, Labour Welfare Fund will give facility only in case of death or disability. On death and disability, the Employee Compensation Commissioner, depending on the nature of disability and death and duration of the employment, will declare certain compensation to the employee. The compensation has to be submitted to the commissioner. The employee compensation commissioner will further disperse to the individual or to his next of kin. Maternity Benefit Act. This is to regulate employment of women for certain period before and after birth. Before and after childbirth, and to provide maternity benefit in certain other benefits. It extends to whole of India, which has 10 or more persons, except employees covered under ESIC Act. Every pregnant woman need to serve at least 80 days in 12 months period to avail the benefit from one employer. Woman employee on pregnancy is entitled to avail 12 weeks of paid holidays. If this could be calculated, 6 weeks can be availed pre-delivery and 6 weeks can be availed after delivery. Even if it is not calculated, the total 12 weeks will be eligible for an employee. The leave can be extended by another 4 weeks on the recommendations by a medical practitioner. Miscarriage also will be facilitated with holidays with pay under this act. Gentlemen, we have covered almost all the acts. There are 2-3 acts which need to be discussed a bit on. Equal Remuneration Act. This is to facilitate women employee getting salaries at par with the men employee for same designation for same kind of work. Second is the Payment of Subsistence Allowance Act. This is to facilitate a person who is kept on suspension for his benefits. Any employee kept on suspension for a month, he should be paid with 50% of his benefits. If he is on suspension for second month, the second month salary will be 75%. After second month, he will be paid with total salary. Employment Exchange, compulsory notification of vacancies. Under this, every employer has to disclose kind of vacancies arising in his employment to the Employment Exchange. The Employment Exchange can send people for attending interview. It becomes a right of the employer to accept the candidature or deny. Industrial establishment, conferment of permanent status to workman. Any workman working for more than 240 days, including leave with wages, is entitled to get a permanency. To regulate that, this act assists. Standing order. Standing order is becoming mandatory in all the states across India. Standing order is nothing but making our own rules and regulations, making that authenticated by the authority, and ensuring the following of the standing order by all the employees and the employer. There are model standing orders. In the event of employer who has not taken his own standing order, the model sample standing order is automatically in place for the employee benefits. Industrial Dispute Act. This is to facilitate employees on their disputes for employment and employment related requirements. There is another act called Industrial Establishment National and Festival Holidays Act. This act also applicable all across India. State specific act, as the sound says, National and Festival Holidays Act. Every state declares certain number of national holidays which are mandatorily to be given to all its employees, and every state declares number of festival holidays. Among the number of declared festival holidays, every state stipulates to so many number of festival holiday to be given to the employee. For an example, in Tamil Nadu, there has to be 4 national holidays and 5 festival holidays mandatorily to be given to the employees. There are no bar to be given with the national holidays, but on to festival holidays, the state government declares numerous festival holidays. Among the festival holidays, the employer is allowed to select 5 or more festival holidays to facilitate kind of employees available in his establishment. With this, we have covered the legislations. I would like to touch upon the basic compliances at this point of time. When we talk about compliances, what is compliance? The compliance could be understood to be undertaken on 4 quadrants. First quadrant being the register maintenance. Under this quadrant, every legislation, Factories Act or Shops and Establishment linked with other legislations will have to be maintained with certain kind of registers in certain format which are prescribed by the state governance. We need to maintain all these registers on a monthly basis. Second quadrant being the returns. Under all the legislations, any establishment or every establishment need to submit a periodical return, which is nothing but a consolidation of monthly activities for that particular legislations. Third quadrant is the display of abstracts and notices. Every establishment should have the abstracts and notices displayed in a prominent place where any or all employees can see the displays and abstracts. There need to be 7 abstracts and 7 displays. Abstract is nothing but the simplified form of any legislation. Notices are the mandatory requirement or an information need to be given to the authority or to the employees. Fourth quadrant is the inspection. When we have all the registers in place, when we submit all the returns periodically, when we are set with the abstracts and displays, we should not have any problem with the handling of inspection. If we take care of all these 4 quadrants, our compliance is fully intact. With this, gentlemen, I conclude my lecture here, leaving you for posting questions.